In this video, we will be discussing Shariyat Act, Muslim Personal Law, Shariyat Application Act of 1937. The question can be asked to explain the salient features of the Shariyat Act of 1937. Here, we have 6 sections in total, in which section number 5 is repealed. Speaking of its introduction, this Shariat Act was enacted in 1937 to regulate the personal laws governing the Muslims in India. And this act was implemented to ensure that all the personal matters of the Muslims being governed by their Shariat law. And this act came into force on 7th October 1937. Now, speaking of the first section speaks of its short title. So it is called as Muslim Personal Law Shariat Application Act. And this act came into force in the year 1937. And this is the short title and extent. This act extends to whole of India. Then comes second section. Section number 2 deals with application of the personal law. So according to section 2, if the parties to the case, if both the parties are Muslims, at that point of time, Muslim personal law will be applied. So these are the 10 matters in which Muslim personal law is going to be applied. First matter, interstate succession. Second, special property of females. Third, marriage. Fourth is dissolution. Fifth is maintenance. Sixth is dower. Seventh is guardianship. Eighth is gift. Ninth is trust. And fifth is waqf. For these 10 matters, it is the Muslim personal law which is going to be applied. And here, one thing to note is it's mandatory to apply the Muslim personal law for the following matters if both the parties are Muslim. And here, courts are not only empowered but also to administer the Muslims are pertaining to this following 10 matters. This is section 2, application of personal Muslim law. Then there are certain matters which are exempted from application. Agricultural land, waqf created for charities, then charitable institutions, religious endowments. For all these matters, court cannot apply Muslim law on the question for this particular thing. Like for these 4 matters, Muslim personal law will not be applied. It is exempted. Then comes section 3. Section 3 talks about power to make declaration. Here, if the person is satisfied, if the authority is satisfied, any person satisfies the authority, if any person who satisfies the authority that he is a Muslim and is competent to enter into a contract, and if he is a resident of that particular territory, then he may declare by filing a prescribed form uh, and then file it before the authority declaring that he desire to get the benefit of section 2 where pertaining to these 3 matters, adoption, will and legacy. Pertaining to these 3 matters, LAW law. You can apply the trick to remember LAW law. L legacies, A adoption, W will law. Pertaining to these 3 matters, Muslim personal law to be applied. So that is power to make declaration in case if the party satisfies the authority that he is a Muslim, competent enough to enter into a contract, is a resident of that particular territory, then he can file it in a prescribed form before the authority and ask to apply for these 3 matters, adoption, will and legacy, the matters, the personal Muslim law to be applied in this 3 matters, LAW law, legacy, will and adoption. Then comes section 4, law, rule making power. Rule making power, it is a state government which gets the power to make rules pertaining to the prescribed authorities in front of pertaining to prescribing authorities for its declaration and pertaining to filing of the fees. Then comes the sixth section. Fifth section is repealed. Section number 5 is repealed. Section number 5 is not no more there in the act. It is omitted. Section 6 talks about few laws which have been repealed after this act came into force. So section 6 of the act provides few laws which were outdated. and which were inconsistent with the act were repealed. Those were Bombay Regulation. It's Section 626 of Bombay Regulation 4 of 1927 Act, and Section 16 of the Madras Civil Court Act, and then Section 3 of the Oath Laws Act of 1876, and then Section 5 of the Punjab Laws Act, and Section 5 of the Central Provisions Law, and Section 4 of Ajmer Law Regulations. These were the provisions which were repealed as they were inconsistent with the act and they were outdated. So this is all about the Shariat Act. It's a very short act where we have only 6 sections, and that also section 5 is repealed. So section number 1, short title and extent. 2 is application. 3 is power to make declaration pertaining to 3 matters, LAW law. I gave a trick to remember. Legacy, will, and adoption. And rule making power is with the state government. And then few laws were repealed. See you all in the next video. This is just a short act.